observed defendant standing in a roadway and soliciting from passing vehicles. Officer also observed defendant entering the lane of moving vehicles and impeding traffic. Upon activation of emergency lights, defendant walked towards the officer's vehicle in an aggressive manner while screaming. Defendant was detained for officer safety. As officer began guiding defendant towards the vehicle, defendant tensed his arms and physically pulled away. Officer issued verbal commands to defendant to advising him to stop acting up, but defendant continued to pull away. Officer pushed defendant against the patrol vehicle and defendant spat on the vehicle and continued his aggressive behavior.
What was he doing wrong?
So he was standing in the middle of moving lanes of traffic.
Okay. Did they ask him to move?
So they activated their emergency lights and the defendant walked towards them in an aggressive manner, screaming and for officer safety.
They couldn't just ask him to get out?
Your Honor, based on the dims, they were walking towards them in an aggressive manner, screaming for their safety.
I mean, sure, off the face of it. My other issue would be very.
How did he interfere? Is he interfering with what duty?
Trying to detain him, Your Honor, as they were trying to detain him, just can't see that.
Detain him for what?
For officer safety, Your Honor.
I mean, theoretically, you could say that about anything, about any situation, right?
And in this situation, Your Honor, he was walking towards them aggressively and screaming. And Your Honor, straight from the dims, defendant's behavior escalated rapidly, causing Leo to detain him for officer safety. Defendant was walking towards their vehicle in an aggressive manner while screaming.
And they couldn't try to de-escalate the situation, you know? Hey, buddy, calm down, relax. We just don't want to see you get hit by a car. You know, 9 times out of 10, you get more with honey than you do with vinegar. So all it does, it ends up as a pissing contest. And who's going to win when you have the power of arrest? You know?
Your Honor, and I will say immediately when, this is from the dims, officer activated the control lights and defendant immediately walked towards them in an aggressive manner. So they didn't have a chance.
Is that against the law?
Or he aggressively approached them for their safety to detain them. They didn't give him a chance to tell him. He didn't give the officer the chance to stop. He immediately after the lights were activated, approached them and aggressive.
I think all the issues that we have is them actually approaching him, also saying, but also the interference as well. I mean, the duty is that the duty to detain him, and the dims, it just says that he senses out his way. To what extent does he do that? Does he run away? You know, it doesn't even rise to the level that, you know, we can really say, is this interference or not? I don't think that there's probably on that front.
I mean, it says here, did then and there unlawfully with criminal negligence. Tense up and pull away, interrupt, disrupt, impede, and interfere with a peace officer while he was performing a duty and exercising authority imposed by law. What criminal negligence? What the hell does that mean?
Your Honor, he was tensing his arms, physically pulling away, he spat on the police vehicle. He was given commands to stop tensing up and to continue to pull away.
There you're looking at the definition of.
That's exactly what I'm doing.
Occurs when.
What does criminal negligence mean?
Says that what I have here is criminal negligence occurs when a person ought to be aware of a substantial and unjustified risk that will occur that fails to foresee it.
And Your Honor, I would argue this does rise to the level of criminal negligence. He was told to stop. But he continued to
After he's already arrested. right? I mean, here it says, with respect to circumstances surrounding his conduct or the result of his conduct, when he ought to be aware of the substantial and unjustifiable risk that the circumstances exist or result will occur. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the actor's standpoint. Was his conduct such a gross deviation, or was it the fact that they both end up in a pissing match? You know?
Yes. Your Honor, I would argue that it does rise to the level of criminal offense. He saw the emergency lights activated. He approached them aggressively screaming. Officers detained him because he was approaching them screaming.
I'm going to find no probable cause.
On December 29th, officer conducted a traffic stop in Harris County with no front license plate. The driver had light out. Officer approached the driver's side of the vehicle and informed the defendant of the violation. Defendant was unable to provide a driver's license. Officer asked for consent to search the motor vehicle. Defendant agreed. He stepped out of the motor vehicle and pulled out a bag of marijuana. Officer instructed the defendant to put the marijuana on the vehicle, at which point the defendant fled on foot heading north on Mayberry Street and was found in the backyard hiding about half a mile from the traffic stop.
You say he told him to stop?
So he stepped out of the motor vehicle, had the bag of marijuana. Officer instructed him to put the marijuana on the vehicle. Defendant fled on foot.
Did he tell him to stop?
Checking the camera tag already. No, Judge, this from the DMs, defendant, officer instructed the defendant to put the marijuana on the vehicle, at which point the defendant then fled the scene on foot heading northbound.
Was he arrested at that point?
He was, there was a traffic stop being conducted at that time. I don't believe, it didn't say whether it was or
Yeah,
not.
all right, I'm going to find no PC. Okay, take a seat.
County, Texas, officer was dispatched in reference to a report of multiple gunshots in the area. Officer met with the community members who stated that there was usually a group of individuals who think outside drinking alcohol and occasionally shoot guns into the air. The community members pointed officers in the direction of a property, and officer observed 4 males with alcohol beverages in their hands on the driveway. Officer observed multiple spent shell casings near where defendant was previously standing. Officer detained defendant and observed the end of an unholstered semi-automatic handgun protruding from the pocket of his shorts.
How do you know he fired it?
There was shell casings near where he was previously standing.
There was 4 people.
But the shell casings were where he was previously standing.
So? We don't operate on hunches, right? This is the law. It's either, black or white, not gray. Unless you have something more.
I'm taking a look at the dims right now, Your Honor. This is straight from the dims. Straight from the dims, Your Honor, based on the reports of gunfire, the proximity of the spent shell casings to where the defendant was standing. And
The officer could have done one more thing and made one more question, but no. I'm going to find no probable cause in the case. Please, sir.
The officer in Harris County dispatched with theft at Walmart. Defendant and co-defendant were detained by the loss prevention officer on scene. The loss prevention officer advised that the defendant and co-defendant came into the store, grabbed items totaling $189.47, and walked past all points of sale without paying. And I also have the list of the items if you'd like.
How much?
$189.47.
Then you have a problem. Because it's charged as a class A and someone at intake messed up.
See, that's what
You charge it a class A, yet what you're alleging is a class B amount. So at this time, I'm going to find no probable cause. They filed it wrong. They filed it wrong, but that doesn't mean that they can refile it. So you have to be on the lookout, because at some point they'll have it there. They may have it indicted and another warrant will issue. Do you understand? Go ahead, take a seat for me, please.
that would be a match to the co-defendant probably.
Correct. That's right. You guys alleged 187, but you charged it as a class A, which is 750. So that therefore,
Yeah.
right.